where, for example, counsel has found himself trying to represent a defendant and a couple of third parties, and they've had conflicting interests, and it's all ended in tears. So do be careful from the point of view of a defendant's solicitor of the risk of conflict of interest. And then what if you're the third party solicitor? You're naturally going to be cautious in that circumstance that you don't want to drop your client into difficulty, to put your client in a position where he or she may be facing money laundering allegations or other allegations, other criminal allegations. And you're bound to be something of an outsider in the confiscation proceedings. You're late to the party. You won't know perhaps what's gone on in the trial. There may have been earlier stages in the confiscation proceedings which are relevant to you, but you won't know the history. So you have some real difficulties as a third-party solicitor. And of course, you may be in a situation where you don't want to create additional difficulties for the defendant, particularly if you're acting for, say, the defendant's spouse or something like that. And as I've touched on already, there might be competing claims of different family members. You can get into all sorts of complexities via Section 10A proceedings. So do remember that normal property law and family law and trust law principles do apply in confiscation, even going back to the case of May, which we all know and love in 2008. One of the things that was said in the sort of half dozen points summing up at the end was there's nothing unusual about the law of confiscation in terms of property law, family law, trust law. We are applying those principles, but we're looking at them in the context of confiscation. And we're not doing a tracing exercise. So whereas under Part 5 of POCA, the civil recovery side, that is focused, if you like, on the assets, Part 2 of POCA, the confiscation side, is focused on the defendant more so than the asset. And of course, as we know, the available amount of the defendant is not limited to assets he has acquired through criminal conduct. It's all his assets. So it's not that sort of exercise of trying to attach criminality to equity in a property, to that being a tainted gift to the wife or whatever. That sort of analysis is not appropriate in confiscation. Okay, I've got, well, let me stop there and say, is there any more questions about Section 10A or even about POCA generally?
Sorry, I've got one, David. Is
yes.
not the rule of thumb with Section 10A is if you can, stay well away.
Yes.
If you're a third party and say there are concurrent proceedings, you don't want to compromise your position by saying something in the criminal case which you might not want said in the civil jurisdiction, for example. Also, there's the money laundering side, and also there's the complexity side. Who wants a Crown Court judge to be deciding these very complex issues? You're much better having somebody who you've got more confidence in, i.e. protecting your interests. Therefore, you're best off either leaving it for the civil courts to decide if there's a concurrent civil action, or waiting till the enforcement stage and doing it the old-fashioned way before we had Section 10A and defending your position there and then.
Yes, but if the prosecution have said, right, we want a Section 10A determination, and you are, let's say, the spouse with you would say a 50% interest in the matrimonial home. And you're given the opportunity to come to Crown Court and make representations in the Section 10A, and you don't, then when it comes to enforcement and so on, you've either got to say you were not given an opportunity to make representations, or you've got to say there would be a serious risk of injustice. And we get back, a serious risk of injustice was talked about in Benjafield, I think, a very long ago case, which basically said that any risk of injustice can appropriately be called a serious risk of injustice. But because it's not a risk of serious injustice, it's a serious risk of injustice. But even so, you're kind of up against it, I would have thought, if you've been invited, as it were, to make representations in the Crown Court and you've declined to do so.
The point I was making in a rather ham-fisted way is this, is if it's a simple 50-50, yes, go and say that. If it's more complicated, go and say it's too complicated for you to deal with.
Yes, maybe so. Even with a 50-50, if there's a mortgage and there's mortgage payments, and let's be stereotypical and say the husband is earning and the husband is the criminal, and he has used perhaps proceeds of his crimes to make the mortgage repayments, then you might have difficulties going into the Crown Court as the wife and saying either I had no idea that he was engaged in criminality, or perhaps, well, yeah, I did, and I knew he was paying the mortgage, but I still want half it. So yes, there are various complexities and various difficulties.
But so it was intended to make the whole process simpler, but has in fact made it more complex.
Yes, and I think a lot of the time prosecutors are not very keen on it, frankly, because it is more complex, and because it requires them to identify the third parties and go out and offer them an opportunity to come to court and complicate the confiscation proceedings, which are sometimes complicated enough anyway.
And if you are a third party, you're best off initiating a divorce anyway. Get the civil courts to deal with it.
Yes, I think so.
Protect your asset, or 50% or whatever you've got.
I'm looking at the clock and I've got 2 minutes. Can I quickly mention the Law Commission consultation? Because it will take me to postponement, which you mentioned earlier. And one of the things which was of interest in the Law Commission consultation was that their understanding of Section 14 and postponing proceedings before sentence was different, certainly from mine, and I think for most people's, because what they were saying is that the 2-year time limit does not apply to the making of a confiscation order. It applies to the starting of confiscation proceedings. So they are saying, well, within 2 years of conviction, the court has got to have said, here's the Section 18 order, here's a date for Section 16 statement, here's a date for Section 17 response. And if they've done that, they've done enough to satisfy Section 14. That seems to be what the Law Commission thought. So it's 2 years to start 2 years to start the process, not 2 years to end the process. And that is why they suggested that 2 years was far too long and it ought to be 6 months. And in fact, they also suggested, well, what's the harm in doing the sentencing first, really, and doing the confiscation after, which is what happens in practice, but it's not the way that Section 14 is laid out. And then quickly, if I may, I wanted to mention a couple of points from the Law Commission consultation. One is that they came up with the idea that instead of benefit obtained, confiscation should be structured around benefit gained, and they're using gain in the Theft Act 1968 sense. And they should look at the intention of the offender, so that the money launderer, for example, who didn't intend to gain the money he's laundering, he's just passing it through his bank account, shouldn't be treated as having obtained that benefit for confiscation purposes. That was an idea that was mooted in the consultation. And finally, if I may, just very quickly, they also mentioned the idea of what they called EROC, early resolution of confiscation. And they suggested that there be a formal meeting of the parties without the judge to try and thrash out the issues before it gets to court, before it gets to the confiscation hearing, try and thrash out the issues and either do a deal, as we do in sweaty little rooms at the Crown Court up and down the corridors, or at least to identify very clearly what the issues were that the court needed to address. And that meeting should happen at an early stage without the judge, not at court. And then the upshot of that meeting should go to a hearing before the judge, and he be told either we've agreed some figures or we've agreed to disagree about A, B, and C. So I thought that was some very interesting ideas coming from the Law Commission consultation. We shall see what happens later this year when they take this to the next stage. So sorry for barging in on that, and I've run over my time.
No, that's very interesting, David. I wonder if all three of you could send me through your slides and then I can distribute them. And yeah, well, maybe pending the Law Commission's decisions and what happens, we could all meet again and discuss where we are then, whenever that is. Whenever that is.
Lovely. Yes.
Thank you, Elizabeth, Emma, and David. Thank you for all your help. Thank you, Stephen. And take care.
Thank you very much.
Thank you
very much.
Thank you.
Thanks very much.
Great.
Thank you.